Thank you to everyone who has joined. My name is Emily, and I'm an advisor on the PS&D outreach team. My job is to develop accessible resources that save residents time and equip residents for their transition to practicing physician. These power hours are designed to ease your way by giving you the opportunity to learn from subject matter experts on complex topics. And I'm joined today by Elisa Taub, partner at the immigration boutique law firm Siskin Susser PC. Elisa leads the firm's healthcare immigration practice and primarily handles matters in the areas of physician and nurse immigration. She has extensive experience with J1 waivers, H1Bs, O1s, EB1 extraordinary ability petitions, national interest waivers, and labor certification-based green cards, as well as a variety of other business and family immigration processes. Lisa earned her Juris Doctor degree from Villanova University Law School in Villanova, Pennsylvania, where she graduated magna cum laude Order of the Coif. She earned her bachelor's degree from Washington University in St. Louis and has since co-authored the Physician Immigration's Handbook. She regularly is invited to present for webinars, conference presentations, and to conduct client trainings on the diverse range of topics related to healthcare immigration. She is a member of the Florida Bar, is an active member of the American Immigration Lawyers Association, and has served on several national committees. Elisa is chair of the Labor and Employment Practice Group of the American Health Law Association and is an active member of the IMG Task Force. We understand that immigration is a complex topic, and it is nothing short of a privilege to have Elisa here with us today, providing her expert insights that will help you make decisions about your future employment. So Elisa, welcome, and I cannot thank you enough for being here today. I'd love to give you all just some quick background. Next slide, please. Provider Solutions and Development is a nationally recognized recruiting arm of Providence St. Joseph Health System. And it's after working with our internal Providence residents for years, where it was evident that there is a gap in the resident preparedness for the job market. So we as an outreach team established ourselves not to recruit, but rather to fill the knowledge gap that exists in your job seeking preparations. And we do that by bringing forward resources delivered to you in accessible ways so that you can be proactive and show up to recruiting conversations equipped to put your best forward. So today, in this hour, we're going to be talking about J1 waivers, shortage waivers, key H1 concepts, and we want to dedicate some time at the end for Q&A, but also encourage you to drop your questions in the chat as we go. So with that, Elisa, I will turn it over to you.
Fantastic. Thanks so much, Emily. And as Emily mentioned, feel free, if you have questions along the way, to drop them in the chat. I'm usually pretty good at monitoring them. So if there's something that comes up in the course of conversation, I'm happy to answer it as we go. I also want to mention, though, as you do ask questions, that this is not a confidential setting. So I am not able to provide personal legal advice in this environment, but always happy to schedule a phone call or a Zoom meeting, separately to talk about your personal immigration questions. So as we get started, and I'll go back to the last slide for a second, you can see our agenda for the day. We're going to cover a lot of ground, and I hope that this is helpful for you in your job search. I will try to provide as much practical guidance as I can on things that you should be thinking about as you're going through your job search and talking with employers. So the first thing to know, as most of you, already know, physicians, when physicians come to the United States from other countries, they typically come either on a J1 visa or an H1B visa. That choice of whether to come on a J or an H typically isn't decided by the physician. It's usually decided by the residency program that you match with. But it's a really important decision. And it's a little bit, it can seem unfair at the end of the day that physicians don't get more of a say in that choice because you don't always know what the ramifications are of it up front, right? But that decision, whether you come on a J1 or an H1B initially to come to the United States, really sets you up on a particular pathway for your residency, for fellowship, and beyond. And it's really important to understand what those ramifications are. And so that's a lot of what we're going to cover today are, if you're here on a J1 visa, what does that pathway look like? If you've come initially on an H1B, what does that pathway like? And what are the things that you need to think about as you're looking for a post-training position? So let's start off initially talking about J1 visas, J1 waivers, because that is the most common status that physicians do come to the United States using. Most residency and fellowship programs prefer the J1 for a lot of reasons. Most importantly, it's not as expensive as H1Bs, but it also gives a physician more time, right? You can be on a J1 for 7 years for training, whereas an H1B, you typically can only use that for a max of 6. So there are a lot of reasons why most physicians come on Js these days. But a J1 has a really important requirement attached to it. We refer to that as the home residence requirement, the 2-year home residence requirement. Some people call it the foreign residence requirement. It has a lot of nicknames. But this is the crux of the J1 for every physician who comes to the United States in that status. What the 2-year home residence requirement says is that when you come to the United States on a J1 visa for the purpose of engaging in graduate medical education, so residency, fellowship, you are required to return to your home country for 2 years at the conclusion of that program. And unless you comply with that requirement or obtain a waiver of it, you have 3 very important restrictions on your immigration pathway in the United States. The first is that you cannot obtain an H-1B visa. The second is that you're ineligible for a green card. And the third is that if you do seek some other status besides H-1B or green card, like an O-1, you have to leave the United States, obtain a visa stamp in that category, and then return in order to effect that change. In other words, you can't change from J1 to any other status from inside the US if you don't obtain a J1 waiver. So the J1 home residence requirement is a really key part of your J1 status. It's also important to know that it doesn't go away with the passage of time, and it doesn't go away through marriage to a US citizen. The only way to address the home residence requirement is either to comply with it by returning to your home country for 2 years post-training or obtain a J1 waiver. So it's really, you sometimes can kick the can down the road by maybe switching to another status like O1 for a period of time, but ultimately the J1 waiver is going to be a barrier to obtaining a green card in any category if you don't deal with it at some point. The most common way that physicians obtain a waiver of the 2-year home residence requirement is by making a 3-year commitment to work full-time in an underserved area. Of those kinds of waivers, the one that most everybody has heard of is Conrad 30. The Conrad or State 30 programs are the programs through which every state, plus the District of Columbia, plus Puerto Rico, and some other territories, can support up to 30 physicians in a federal fiscal year for one of these waivers on this basis. Every state and territory gets the same 30 waivers. So New York and North Dakota have the same allotment. That allotment doesn't fluctuate. It is the same every year. And when we talk about per year, we're talking about the federal government's fiscal year, which starts every year on October 1st. So for right now, we're in the 2022 fiscal year, but come October 1st, 2022, for the US government, the calendar switches to 2023, and that's when the new allotment of waivers will be available. We also have several interested government agencies. These are agencies of the US government that are authorized to issue waivers in unlimited numbers, and I've listed several of them on this slide. I am proud to tell you that there is a new federal agency that is coming online this fall called the Southern Crescent Regional Commission, SCRC, that is going to be able to provide unlimited waivers in parts of Virginia, North and South Carolina, Georgia, Alabama, Mississippi, and Florida, almost all of Florida. The agency is up and running, and it was the infrastructure bill last fall that provided the funding for this waiver program to be able to take effect. Our office has been working with the agency to draft the requirements, And more information is going to be rolling out over the course of the summer. It's literally just gone public in the last week. So you all might be the first people to be hearing, some of the first people to be hearing about this new program. We're super, super excited about it, and it will provide a major boost to the ability of employers and doctors to be able to go through the waiver process in the southeastern part of the United States. The program is modeled somewhat on the Delta Regional Authorities program, which is the DRA that's listed on this slide. But like I said, it will have unlimited waivers for specialists and primary care physicians, much like the DRA does. I'll mention real quick that HHS waiver that is listed there. HHS has unlimited waivers, but has a very limited program. They serve outpatient primary care physicians and hospitalists who work in underserved areas called HPSAs that have a score of at least 7 or higher. And physicians who go through that program have to start work within 1 year of finishing residency. So stated differently, you cannot have more than a 1-year fellowship and obtain an HHS waiver. It's truly for primary care and hospitalist physicians. So that is a fantastic program. We use that a lot. So we're excited because, for example, in Florida, between the SCRC and HHS, that the ability to obtain waivers down there just greatly expanded. All right. So there are other types of J1 waivers, though. Underserved area waivers aren't the only kind. HHS, in addition to the clinical waiver program that I just mentioned, also has a waiver program for people who are engaged primarily in research. It doesn't have to be bench research, it can be clinical research, but you have to be doing high-level research in an academic institution in order to qualify, and that institution has to sponsor your waiver. The challenge with HHS research waivers right now is that they're taking nearly 3 years to be approved. So even though you don't have to work in an underserved area for 3 years, the actual process of applying for and getting those waivers approved is significantly long. So at this point, our recommendation on those is really as a last resort, right? You have no other waiver option available to you. HHS research might be a good option, but until their processing times come down, it's not something that we are really recommending on a wide scale basis. That's changed. I mean, years ago, we used to do them a lot. They used to do them in 4 to 8 months. But there are a whole host of reasons why it's lengthened. And unfortunately for right now, we don't expect that to change. There are also hardship waivers. If you are married to a US citizen or permanent resident, or if you have a US citizen or permanent resident child, you may be eligible for a hardship waiver. We'll talk a little bit about, hardship waivers could be an option, also persecution waivers, which are akin to an asylum claim, but are not an asylum claim. But if you could show that you would be persecuted on account of some protected class like race, religion, political opinion, if you were to return to your home country to comply with the 2-year home residence requirement, a persecution waiver could be an option. Persecution waivers do not require you to have a qualifying relative the way that hardship waivers do. In another slide, we're going to talk about the differences between the hardship persecution type of waiver and the underserved area waivers, because there are some key differences between them. There we go. And here we go. So on the left-hand side of the screen, you see the shortage area waivers, and on the right-hand side of the screen, you see the hardship and persecution waivers. A few things about them. I mentioned with shortage area waivers, or I should have mentioned that, and we'll talk a little bit about the process later on in this presentation, but what happens at the end, once your waiver is approved, your employer will petition to change your immigration status in the United States from J1 to H1B. And with a shortage area waiver, that happens all within the United States. Doctors who get shortage area waivers are automatically exempt from the H1B cap. What that means is that you never have to worry about whether your employer is a for-profit or nonprofit entity. You don't ever have to worry about going through a lottery to get an H1B. But the same is not true for hardship and persecution waivers. Physicians who get those waivers are just like any other person seeking a visa in the United States. They don't get any benefit from that waiver other than they're not prohibited from getting an H1B, but all the usual H1B rules apply. So if you go to work, if you're not married to a US citizen or permanent resident, and you're getting your hardship waiver based on your US citizen child, you're going to need to figure out what your status is going to be after your J1 time is done, because you can't use a J1 for an attending position. It's only for training. So how do you transition to what comes next? Are you going to be able to seek an H1B, or you're going to need to look at an O1 or some other status to be able to continue working in the United States after your training program is done? Because if you are seeking the H1B, then the cap is going to be a barrier. And we're going to talk about that further toward the end of the presentation. With shortage area waivers, you can change status from J to H1B here in the US. No need to take any special trip to get a visa stamp, but it's the exact opposite with hardship and persecution waivers. When your J1 status comes to an end, you have to leave the United States, apply for a visa stamp at a US embassy or consulate, receive that stamp, and then return to the US before you can start work. Now, in years past, that was kind of more a pain in the neck than anything else. But right now, as some of you might know, it can be really challenging to get visa appointments abroad. So this is a complicating factor now. I have a client who just received a hardship waiver approval, and we've just set her start date back from August 1st to October 1st because the consular processing of her visa is taking a little bit longer than what she initially expected. So it's really, really important to think about that as a really critical issue if you're deciding between a hardship waiver or a persecution waiver and a shortage area waiver, is exactly when you might get to start work based on visa appointment availability. On the flip side, doctors who do shortage area waivers have to complete working in the underserved area for 3 years before they are eligible to complete green card processing. Doctors who get hardship or persecution waivers are immediately eligible to proceed with green card processing. So if you're married to a US citizen or permanent resident who might ultimately sponsor you for a green card, that's the scenario where maybe a hardship waiver or a persecution waiver could be in your interest, because you can go directly to green card. You don't have to wait an extra 3 years to be able to go down that road. So sometimes that's a key factor in that decision. And then the final key difference between these kinds of waivers is that for a shortage area waiver, you do need to have a job lined up in order to apply. You have to sign a contract that complies with all the waiver requirements before that application can move forward. But a hardship or persecution waiver, you can file way before you have a job lined up. So sometimes, folks like to do that so that they don't have to worry about having a job in just the right kind of area. The other thing I'll talk about real quick that's not on this slide is that the processing times by the government on hardship waivers and persecution waivers, but specifically the hardship waivers right now, is really long. We're talking over a year to get those approved, where the shortage area waivers typically can happen all within your last year of training. Between the fall and the spring, the whole thing is done. So it's a little more predictable of a process in some senses. So there's your kind of comparison and contrast between the two types of waivers. You can see there are really legitimate differences between them. I know sometimes I talk with physicians and they throw around, well, I might just want to do a hardship waiver. And I'm like, okay, but let's talk about why and what the ramifications of that are, because it's really important to understand if that gets approved, you're going to have to travel. And depending on where you're from and what your interests are, that could be an issue. Okay. So let's talk a little bit more about the shortage area waivers in depth. I'm not really going to talk too much more about the hardship and persecution waivers because whether you're eligible for one of those, it's a very fact-intensive discussion. But shortage area waivers have some very key issues to discuss and key parts of them that I think it's important for you all to understand as you go through this process. So here is the process, and you can see 6 steps. It's complicated. It's not like a 2-week, we file an application and it's done, I start work kind of a thing. My best advice, and you'll see this come up a few times in this presentation, is it is never too early to start looking for a waiver job if going through the shortage waiver process is what you're planning to do. You could be PGY1 on the front end of your residency knowing nothing, and you can start networking with employers. It is really important, in my opinion, to do that. It sets you up in the best possible way to get the waiver you want in the place you want it in the time frame that is necessary for you to start work on time. So these steps all happen in your last year of training. Typically, most J1 waiver programs open October 1st. So October 1st of your last year of training is when your program likely is going to open. There are some exceptions to that. There are some programs that open before that. Like Georgia opens in August, and New Mexico, Virginia, Indiana, Texas open in September. And then there are a bunch of others that open in October. But this process is going to start in your last year of training. It takes a good month or so, 4 to 6 weeks, to prepare and file a waiver application. So if you're really gung-ho that you've got to have this waiver application filed in October and you're only signing your contract on October 1st, that's going to be a tall order. Plan ahead, for these processes to take the time that they need, and make sure that you're, engaged in your job search as early as possible. A few things about these steps that I'll just fill in for you. The DS 3035 that's listed there in step 1 is a U.S. Department of State application. Every single J1 waiver is going to have one of these, whether it's a shortage waiver, hardship, persecution, HHS, whatever it is, they're all going to have a DS 3035. That establishes a case file for you with the U.S. Department of State. That agency is a very key role to play in J1 waiver adjudication. So that's a really important first step. As you see, then we file with the relevant government agency. That would be the state or federal agency, or USCIS if it's a hardship waiver. They'll recommend it. They send it back to the Department of State, where it matches up with that file that was initially, established for you in step 1. The Department of State then reviews and recommends your waiver, sends it to USCIS, who ultimately will approve it, and then you change status to H-1B. So no matter what program you're going to apply for a waiver in, Conrad 30, DRA, ARC, the new program, it's going to follow these 6 steps. How much time it takes, when you have to file the initial step, all of those things are going to vary, but you're always going to go through these steps. I will tell you that it's that initial government agency application, that step 2 and 3, that are the heavy lifting on these cases. The Department of State and USCIS typically approve all the waivers that get to them. It just takes time for them to review and give their stamp of approval, but typically that's the low stress part of the case. The high stress part of the case is step 2, filing with the relevant government agency to ask them to provide their initial support. Some basic things to keep in mind with shortage area waivers. Initially we talked about 3 years full-time underserved area. The kinds of underserved areas that you're looking for are either a primary care HPSA, an MUA, or in some instances an MUP, which is a medically underserved population. And that website that I've listed there is the government website that you can use to look up underserved areas. There's actually a box on that page that says find shortage areas by address. And you can type in any street address in the United States and it will tell you if it's underserved or not. And what you're looking for again is primary care HPSA, MUA, or MUP. It's okay if you're a specialist, you're still looking at primary care HPSA. The reason it's called primary care is because it's the ratio of primary care providers to population that is largely what's being assessed there in that designation, but it applies across the board. So don't worry that if you're a specialist, you shouldn't be looking at that. You look at that regardless. What you want to ignore are dental HPSAs and for the most part, mental health HPSAs, although sometimes those are relevant for psychiatry. What happens if you look for a job, you use that tool, and it tells you that the location isn't underserved, but the employer you're talking with is, certain that they've done a waiver before? There are waivers called flex waivers that are available to physicians who don't necessarily work in an underserved area, but who will serve underserved patients. Every state has its own rubric, its own rules for how to qualify for a flex waiver. It's important to know that they can only use a max of 10 of their 30 waivers for flex, and the 10 do come from the total of 30. It's not an extra 10. And not every state uses them. Off the top of my head, I can tell you like Texas and Indiana don't use flex. I don't think Missouri does either. Most states do use them in some way, shape, or form, but they're definitely, if it's a high competition state like New York, where they get well over 30 applications every year, it may be a little more difficult to get a flex waiver in a competitive state than it would in a state that doesn't necessarily use all of its waivers every year. Notably, the federal agencies, DRA, SCRC, ARC, HHS, they cannot do flex by law. Like you can't just say, oh, well, I'll ask them. They can't, they're not legally allowed to do flex waivers. So you must work in an underserved area to qualify for a waiver that is sponsored by a federal agency. When we talk about full-time, that's considered to be 40 hours a week of direct patient care. It does include charting and anything that relates to the care of a patient, but it does not include like teaching, admin time, meetings with your boss, things that don't relate specifically to patient care. It doesn't include call time, doesn't include travel. HPSA stands for Health Professional Shortage Area. And it is a designation that is provided by the Federal Department of Health and Human Services through its Health Resources Services Administration to designate when there is a lack of or a shortage of healthcare providers. And as I mentioned, for the primary care HPSA, that's based on a ratio of primary care providers to population. And I think they even include like advanced practice with APPs in that calculation as well. And then the final thing that is part of this basic like standard requirement for shortage area waivers is that in addition to working full-time, in your contract, you have to make an agreement that says that you will start work within 90 days of when your waiver is approved. And this requirement causes a lot of confusion. The law says you have to agree to start work within 90 days of waiver approval. It does not say you actually have to start work within 90 days of waiver approval. So if your waiver is fully approved in January and you finish your fellowship in June, you're not going to be able to start work within those 90 days, and it's okay. You satisfied the requirement by making that agreement. And their policy rationale for this is that the government doesn't want people to be applying for these waivers years ahead of when they can actually start work. They want you to apply in the fiscal year when your training is going to end so that the allotment is true and that folks are carrying out their waiver requirements at the time that they need to. So that's really what that's focused on. It's not focused on making sure that you start work before you're ready to. All right. So these are the things that are pretty much universally the same for all J1 waivers, right? For all of these shortage area waivers. Let's talk about the things that aren't the same, which is everything else. How do they treat primary care versus specialists? It's different. Filing deadlines, the amount of time it takes to get a decision on your waiver, whether the state is going to come back and ask you for a bunch of extra things or whether they just approve it in a couple of days with no questions asked. They're going to require your employer to provide evidence that they tried to recruit a non-J1 physician. What's that going to look like? It's going to differ. Your employer is probably going to have to provide some kind of payer mix or demographic data for the practice site that you're going to work at. The format for that will be different in every state and every federal program. Your employer is going to have some sort of sliding fee scale or charity care policy for patients that can't afford to pay full fare for their care and maybe are uninsured. How we prove that, what we have to submit is going to be different in every case. And importantly, the provisions in your employment agreement are going to differ in some small way in every single state and federal program. So looking at all of these variations, if you're applying for a Conrad 30 waiver in Illinois and your friend is applying for an HHS waiver in some other state, your waiver experiences are going to be drastically different from each other. Illinois has a filing period that spans the month of October. They make decisions in December, and then the case moves on from there. And they have a complex method of determining who gets their 30 waivers because it's a very, it's a competitive state. HHS has no limit. We can file those anytime during the year. We usually get recommendations within a month of when we file. The waiver application is pretty straightforward. I always caution physicians, if you and your friend are not applying in the same state or through the same program, please do not compare notes. Your friend, I hear from folks in New York all the time. All of my friends got their waivers. New York doesn't usually make waiver recommendations until sometime in March or April, and you have to apply by like late November. So you've applied in November, or maybe you submitted your application in October, and now it's March. All of your friends' cases, some of them even have their H-1Bs approved, and you don't even know if New York is going to sponsor your waiver yet. That's very typical. But I know it breeds a lot of anxiety, rightly so. But that it's very important to understand every state and federal waiver program is going to differ from every other one, and not to generalize across them. If you start talking with employers and an employer in one state tells you all kinds of stuff about a waiver, don't assume it's going to be the same if you start talking with employers in different places. Specifically with regard to employment agreements, I've listed on this slide the kinds of things that could come up for immigration purposes while you're negotiating your employment agreement. Now, for my employer clients, I actually review draft contracts before they are provided to the doctor to ensure that whatever that particular state's requirements are, they're met in the contract that the doctor first sees. So we shouldn't have to go back and make J1 waiver changes to the contract. But, think about this. When you're looking at a contract from an employer, there are going to be a lot of things you're going to want to negotiate in that contract potentially, right? You're going to look at your compensation. You're going to look at termination provisions. You might look at non-compete. You might look at all these things, but ultimately there are going to be some things that are non-negotiable because they're required for your waiver. Some states do not allow a termination without cause provision, meaning that you can't just, the employer can't just give you 90 days notice and terminate you. They have to only terminate you for cause during the 3 years of the waiver requirement. HHS has that requirement. Almost every waiver program bans non-competes. There are a few exceptions to that. Indiana allows them, Tennessee allows them, a few other places allow them. All the federal agencies ban them, and most of the states don't allow non-competes. So your American friends are looking at, pretty intense restrictive covenants in their contracts, and J1 waiver doctors largely aren't going to have those. All of the locations have to be specified in your contract by name and address. But what happens if you have one location that's not in an underserved area? Some states have no problem with that. Other states aren't going to allow it. They're going to want you to solely work in underserved areas for all of your full-time work, regardless. You have to be in an underserved area for all of your full-time work, but above that, 40 hours a week, some states won't even entertain that. What if you're going to work in more than one state? I've had it come up where, like in St. Louis, people might work in Illinois and Missouri, or down here where I am in Memphis, Tennessee. A lot of times people work in Tennessee and Mississippi, or in Arkansas. And how does that work, right? Now, around here, the area that I'm in, by Tennessee, Mississippi, and Arkansas is all within the DRA. So a lot of times we can work that out because it's a federal agency. But up in Missouri, if you're talking about St. Louis and Illinois, a state isn't going to want to use one of its coveted 30 waivers for you to work half your time in a neighboring state, right? They're going to want to get the benefit of your services. So it's important to understand how working in multiple states could affect your ability to get a waiver. Salary. Most states don't care, but there are a few like New Mexico and Virginia that require you to have a guaranteed base salary for the entire 3 years of your waiver service that can't deviate. Liquidated damages. Liquidated damages is a clause in a contract that says if one party should breach this contract, for example, if the physician terminates this contract early before the end of the 3 years, that would be considered to be a material breach of the contract. And because it's hard for us to calculate what our damages would be, the employer's damages would be, because of that breach, we are going to set a set amount of liquidated damages that we would be paid, we, the employer, would be paid if the employee terminates this contract early. So if you're a year in and you leave, and the employer could come back and say, you owe us X number of dollars because you left early. Some states require those. Some states don't want them. Some don't care. But you may see liquidated damages clauses as a result of J1 waiver requirements in your contract. Always worth asking. If you see one of those clauses in your contract, definitely ask about whether it's required for your J1 waiver or not. And then finally, we mentioned earlier that full-time work is defined as 40 hours a week. It can also be defined for some block schedule physicians as 160 hours per month. But the state of Ohio decides they want it to say 2,080 hours a year because they've done the math and they decided 40 hours a week isn't really, or 160 hours isn't adequate for them. So sometimes we have some picky states on some of these topics. So these are all the contract variations. There you may see other things. Sometimes the state will want a statement in the contract that says that the contract can't be amended without approval from the state. And like there are some things that might get amended in your contract that the state really, it's not their business, but they'll put that in there because the state wants to sort of, on the one hand, they want to protect physicians from employers who may take advantage of the fact that the physician has this waiver. And on the other hand, the state wants to protect its waiver program so that there's not like any bait and switch going on where, you know, an employer and a doctor represent that you'll be doing this one type of job. And then like 6 months in, you completely change that. And they didn't get the benefit of the waiver that they thought they were granting. So there are reasons why they want to have those types of provisions in contracts from time to time. Okay, so there are contract issues, really important things to consider. So what happens? You get a waiver, you go to work in this place for 3 years, and then something happens after you get there. You get laid off. Maybe you're a hospitalist or an intensivist or something, and you're working for a staffing company and they lose the contract that they had with the hospital. You know, there could be all kinds of things that happen through no fault of your own, and you lose your job. Or you go to this new job and you're there for a little while and you really just don't like it. It's not what you thought it was going to be, or there's some kind of problem. It's very important to know that when you obtain your waiver, the federal government and the states assume that you are going to be working in that waiver job for the full 3 years. That is the assumption, that is the expectation. To change jobs within the waiver period, you need to meet 3 requirements. You need to find a new job and obtain a contract for the balance of that commitment period. So if you only served a year, you need at least a 2-year contract to finish it out. You need to move to another underserved area. If your original waiver was a flex waiver, not working in an underserved area, typically you need to also move to an underserved area, although there could be a legal argument that you can go flex to flex, and that's kind of complicated. But the most important part is needing to show extenuating circumstances. Extenuating circumstances is a high bar. The Immigration Service will look at this very closely. And what they're looking for is either a situation that was unforeseen at the time you got your waiver and outside your control as the physician, or some sort of hardship, or maybe the facility closed. I think in the regulation, the 2 examples given are facility closure or hardship to the physician. You know, if your employer isn't paying you the promised wage, if you've experienced some kind of significant discrimination in the workplace, if you're, you know, being made to provide services that were not what you were contracted to do, you know, there can be a huge factual inquiry to determine whether there are extenuating circumstances. And it's important to know that those have to be documented, not just potentially in a statement from you, but in, you know, I've had clients send me text messages, emails, all kinds of written communications that they had with their employer or with others that document the issues that they were experiencing in the workplace. You know, of course, a layoff is easy, right? You get a termination letter, and if you're being laid off for no cause, then that's easy extenuating circumstances. The example I gave where maybe you're working for a staffing company and the hospital changes providers, easy. Those are like the base, like the essence of extenuating circumstances. But sometimes it can be a really complicated inquiry. I had a client during the height of the pandemic who received a waiver to go work in a small town. And her husband, they thought her husband was going to match with a fellowship in the same place. And it turns out he matched with a fellowship a few states away. And during the height of the pandemic, this emergency medicine physician, was flying every other week in her off week to spend the time with her husband. And it caused a lot of financial stress, a lot of emotional stress on the family. And in the meantime, while she was working, she was in this small town where she didn't know anybody. And because she was an emergency medicine physician during the height of COVID, nobody wanted to hang out with her. So she was really isolated and alone in this small town. And so we were able to show all of her boarding passes and flight receipts to show that she really was traveling every other week during the pandemic. We were able to provide a personal statement for her, talking about all of the emotional stress that she was under, a statement from her husband, proof that he was in this fellowship program and that wasn't really within their control where he matched, all of these things. And her case was approved pretty easily. I think, but it just goes to show you the factual inquiry that you have to do on extenuating circumstances cases and how it's really important. The better your documentation is, the easier it is to make out that requirement. But it can't be, well, I got shut out of a waiver in Florida this year, so I'm going to go take a job somewhere else, like in Idaho. And you get there and you're like, yeah, I don't like living in Idaho. I really want to go to Florida. So now that it's the following year, I'm just going to do a transfer since I don't have to apply for another waiver. That's not going to cut it, right? It has to be something pretty significant to warrant that transfer. Buyer's remorse is not going to be enough for that. All right. I think that concludes our discussion of J1 waivers. And I think even if you're on a J1, I would stick around for some of these H1B concepts, because eventually, if you get a shortage area waiver, you're going to end up in H1B status. So it's important to understand some of the H1B rules as well, because eventually they will apply to you, even if they don't right now. So a few basic things about the H1B. Unlike with the J1, the H1B carries with it a prevailing wage requirement. And actually, before I get into that, let me just define the H1B for everybody so that you have the concept or the general bearings of where we are. An H1B is a visa that is a non-immigrant temporary visa for somebody to come work in the United States in a specialty occupation. A specialty occupation is a job that requires at least a bachelor's degree in some field for minimum qualification or minimum entry into that field. So when we think about H1Bs, doctors are not the only folks that use them, right? Famously, they're used a lot in the IT industry, but also teachers, lawyers, architects, professors of all kinds, engineers, right? All kinds of people who are at least in a bachelor's degree level position could qualify for H1B status. So it is a very popular immigration status. It is the closest thing that we have to an all-purpose work visa. But there are some limitations and pretty strict requirements that go along with it. And the first, as I mentioned, is this prevailing wage requirement. Now, most of the time for doctors, the prevailing wage really isn't an issue. This is the average wage that employers are paying in a particular field, in a particular geographic area. So like the prevailing wage for a physician here in Memphis is going to be different than in Portland, is going to be different than in New York City, right? So the government wants to know that foreign workers are being paid in line with what American workers would be paid. So that's what the prevailing wage is. And most doctors comfortably are earning above the prevailing wage. Is not usually an issue, but it does affect the process of how we file H1Bs. H1Bs carry with them a 6-year maximum. So that means that you can be in H1B status a total of 6 years. However, if you reach certain milestones in the green card process along the way, you may be able to get additional time. Notably, doctors who are facing green card backlogs, like Indian and Chinese nationals, typically are able to get 3-year extensions beyond that 6-year limit forever until you reach the front of that green card backlog. So the 6-year limit isn't particularly relevant there, except you have to make sure you get through the green card milestones in enough time to benefit from them. Folks who are not from backlog countries even still can get some additional time beyond the 6-year limit through going through the green card process. And also you can recapture time that you've spent outside the US during those 6 years. So sometimes I've even at one point recaptured about 180 days for somebody because they spent so much time abroad during their H1B years. An employer must pay all of the fees associated with your H1B petition. That includes the legal fees and the attorney fees that go along with that. This is really important. I know for some folks, they'll find a job with a small practice that maybe never went through the green card process before, or never went through the H-1B process before, and the employer is hesitant to kind of pay all these fees on behalf of the employee, and the employee says, don't worry, I'll pay for it all. We don't want that. It's actually a bigger violation for the employer than it is for the employee. So it's really important for employers to pay those fees so they don't leave themselves open to liability. And we don't want you as the employee to get saddled with fees that by law you're not supposed to be paying. But by far, the most famous limitation on H-1B sponsorship is the H-1B cap. And as I mentioned earlier, for doctors who obtain J-1 shortage areas, this is not an issue for them. However, there is an annual nationwide limit on the number of H-1Bs that the federal government can issue. That limit is hit over and over and over again. This year, there were upwards of 400,000 submissions for 85,000 slots. Y'all can do that math. It's beyond me, but it's bad. The odds of winning the H-1B lottery are very low. I've provided on the slide here the timing of the lottery. So for this year, you know, if you have an H-1B and you're looking to start with a for-profit employer later this year, the cap is met, right? There are no more H-1Bs available under the cap for 2022. You're going to be looking at, you know, filing in the lottery in March of 2023 for an October 2023 start date, and hope that you win the lottery to get there. So it's really, really challenging. If you do win the lottery and you're finishing a residency or fellowship on June 30th, and your start date can't be till October 1st, you also have to consider how you're going to bridge that gap in between, because you're not automatically considered to be in status during that time. So you either need to see if your residency program can keep you around for a little while. You could maybe take a job overseas for a few months. Maybe you want to go home and visit family. But that's a really important consideration, is what you're going to do during, you know, between July, August, September, between when your residency ends and when your job starts. There are some folks who are exempt from the cap, in addition to the doctors who get the shortage area waivers. We already talked about how if you get a hardship or persecution waiver, that does not provide you the same exemption. In addition, if you comply with the home residence requirement by going home for 2 years, you don't get an H-1B exemption. You would come back just like anybody else would. However, there are 3 kinds of institutions that are exempt from the cap, and this applies whether they employ you directly or you work there a majority of the time. So for example, if you go to work for a nonprofit hospital that has an academic affiliation, which is not the second bullet point there under the cap exemption prong. So you work for a nonprofit hospital that's affiliated with a college or university. If you worked for them, that would be cap exempt. But you can also be cap exempt if you work a majority of the time at that facility for a for-profit company. So a lot of times staffing companies are able to benefit from the same cap exemption that the direct hospital hires benefit from. So it's important, if you're on an H-1B for training and you're looking for a job, you want to avoid the H-1B cap, those 3 little bullet points there, the institutions of higher education, the academically affiliated nonprofits, or the nonprofit or governmental research organizations, those are the 3 types of organizations that you're going to be looking for a job with. Underserved area is irrelevant to the H-1B cap. These are the 3 types of institutions you're looking for, regardless of their address. I get asked all the time, this isn't an underserved area, can't we get an H-1B there? No, we can't, unless it meets one of these criteria. So it's really important to kind of take that to heart and know. I think for doctors who are doing training on H-1Bs, the 6-year limit and the H-1B cap are the 2 biggest challenges that you face, especially if you're going to be doing, you know, some kind of subspecialization and you're going to use 5 or 6 years of H time during that training. Can be really challenging to get through those green card milestones in enough time. And I think we have hit the question mark with 8 minutes to spare. So I'm happy to entertain questions that folks have. So please bring it on. Let's see. And I can say, I didn't go through, green card sponsorship in this presentation. It doesn't fit in the time allotment. And also, I think it's overwhelming for that amount of information. But, typically what would come next after you go through the J1 waiver and H1B process, and you start working, in your first full-time attending position, the very next thing you're going to think about is green card sponsorship. And what I can tell you is every employer is going to have different policies about when they start that process and what process they'll support and all of that. And it's really important, I think, as you're negotiating your contract, to ask those questions. Find out from your employer, what is their policy on green card sponsorship? They might tell you they do it case by case. They might tell you after 6 months, they'll get started. I have one employer client that once tried to put it off for 2 years. And I was like, I think that might be a little long, but I get where you're coming from. But certainly great to ask those questions of your prospective employer.
That's great, Elisa. Just want to reiterate that this is open Q&A, so you are more than welcome to come off mute, drop questions in the chat. The time is yours, so all questions welcome.
Lisa, what states are the most competitive?
Oh, great question. Probably New York, Texas, Florida, Michigan, Illinois, Missouri, California, if you're a specialist. I'm trying to think. Maine can be quite competitive based on the way they do their filing system. That's probably the lot of the super competitive states. I guess some states for specialists can be particularly challenging. I mentioned California. Indiana is also challenging for specialists, and Arizona. Washington State initially limits to only 10 specialists in October when they open their program. And then if they don't fill, they'll reopen in April for more of them. So if you're a specialist looking for a waiver in Washington State, making sure your application is filed like ASAP, like on October 1st is hugely important for that. I will say the other state that I find to be challenging, and not because they fill up, but because of their policies, is Ohio. Ohio typically doesn't open its program until January. They have a filing deadline of March 31st, and the 2 cases that I filed there this year are still pending. And they just asked us for a bunch of clarification on information last week. So it's a very, very slow process in Ohio. I find it can work well for Canadian physicians because Canadians are the only folks that can get H1Bs in advance of their waiver. So sometimes Canadians going through the process in Ohio will just go straight to H1B while we're waiting for the waiver to finish up. But for other folks, a lot of times they're faced with having to leave the country for a while because the process is so slow.
Thank you. I have another question I probably won't articulate very well, but can you speak a little bit more to the process in California, just given the corporate practice of medicine law, and then whether they're working for a for-profit but serving most of their time in the nonprofit hospital setting? There's this kind of complexity with who the actual employer is.
Yeah, so in California, the challenge on the J1 waivers is that they will only accept waivers from primary care physicians until July 1. So they will only start accepting waiver applications for specialists over the summer, which by that point, by now, if a doctor who is finishing on June 30th doesn't have a waiver in process, at least, right? They're way behind the time. Mm-hmm. So it's really of little usefulness for specialists in California. Mm-hmm. On the other issues, I think that applies more to H1B sponsorship, but we see it all the time where because of corporate practice of medicine laws in certain states, A hospital can't employ a doctor. The doctor is going to, or through any entity that's not physician owned, right? So a lot of times what will happen is we want to make sure that we're filing the waiver. We want to file the H-1B through the actual employing entity, the entity that is going to be paying that physician's salary, that is signing the contract with that person, whose name is going to be on that pay stub. Just to make sure that we are drilling down to the lowest level of, employment. So for example, if a doctor is primarily going to be working at, hospital X, but they're going to be employed through Hospital X Physicians LLC, it's going to be Hospital X Physicians LLC that's going to do all of the immigration sponsorship, not the hospital itself. And that's really important because later on, when we go to extend that physician's H-1B after they've worked for you for 3 years, we have to provide their pay stubs as evidence that they've been maintaining their H-1B status for that time. So we usually provide their last 3 pay stubs. And if the name of the payor entity is different than what's on the H-1B, that can cause issues. The government will ask us to prove that the doctor has been working for the right entity. So we ask that question very specifically. We want to make sure the federal tax ID number we use that it all matches up. So there's no question about the fact that the person was sponsored. Sometimes we're given the wrong information and we end up doing an application through a wrong entity, and we can correct that later on. Most of the time, the Immigration Service is forgiving of those. We'll just go and amend the name of the entity that's doing the employment and explain that it's all the same, but that was the wrong entity, and usually the government forgives us. Let's see.
Sorry, thank you so much. I came in a bit late. I just wanted to ask about the H-1B visas. So, say for someone who is an international medical graduate, and what would be the kind of visa you want to have? J1 or H1B? Because I understand that you can get some form of transition from J1 to H1B much later after residency when you're doing a fellowship. So if you could speak a little bit about that, thanks.
Are you talking about like on the front end when you first come for a residence?
Yes.
So most of the time that decision is made by the program that you match with, because they'll typically sponsor just a J1. A lot of times they won't give you a choice between the two. There are pros and cons to each of them. Obviously, J1s are going to carry that 2-year home residence requirement. So the need to either go home for 2 years after training or obtain a J1 waiver. So that's one challenge. On the H-1B side, you're hemmed in by the fact that there's a 6-year limit on the amount of time you can be in H-1B status, plus the fact that as you leave your training program, you are limited in the type of employer you can seek employment with because of the H-1B cap. So they each have their own challenges. The vast majority, right now, I think over 80% or just about 80% of international medical physicians, international medical grads are coming to the US on the J. So overwhelmingly, you are going to find that J1s are what is offered to you. And there are a lot of reasons for that. It's less expensive for the hospitals to administer for their residents. They can work them more efficiently. They have a lot more control over that process than for H-1Bs, which have to all be filed with the Immigration Service. The Js are largely going to be administered between the hospital and ECFMG, which is the sole sponsor of J1s for physicians in the United States. And so for a lot of reasons, you're more apt to be offered J1 sponsorship. And I think whether, if you're offered the opportunity for an H-1B, I think if you're planning on only doing, a 3-year internal medicine residency or something that's no more than a 3 or 4 year training program of training, the H-1B is probably okay. But if you're looking to subspecialize, you're going to probably use all 6 years or close to it of H-1B time. And it's going to bottleneck you. You're going to be freaking out and stressing out about green card sponsorship as you near the end of your fellowship because of that 6-year limit, and it will really ham you in. So I think for the J gives you 7 years to train. So for that reason, for folks who want to subspecialize, I find that the J1 is often the better option.
Thank you so much.
You're welcome.
All right, well, we are at time. Elisa, for next steps, how can our attendees get in touch with you?
Great question. So both Emily and my contact information actually is on this slide. My email address is there. If you visit our firm's website, there is a link in the top right-hand corner to schedule a consultation. Myself, Attorney Adam Cohen, and Attorney Megan Moody all work primarily with physicians. And so any of the three of us are super happy to schedule time and chat with you about your specific immigration needs.
Fantastic. And to those who have attended as well, my information is there. If you have any questions about just job seeking preparedness in general, please email me directly or head to pscconnect.org where you will find an entire library of content. You'll be able to register for future power hours such as these, and you can also be connected to advisors who can help you with things like perfecting your CV and cover letter and prepping for an interview. We're here to help. And so we thank you for investing the time, and Elisa cannot thank you enough for lending your expertise today.
My pleasure. It's great to be with you all. And thanks so much for the opportunity to speak with you.
Pleasure. All right, everyone, have a great rest of your Tuesday.
You too.
Take care.